Good morning. I'm Dan DeRosa with 19 News Now, coming to you from our digital desk. We're going to take you live in the Cuyahoga County Court of Common Pleas. Judge Jeffrey Saffold. This is going to be the sentencing of a former Cleveland police officer. And it looks like just as we started, we're going to get a sidebar. And they've been in sidebar for about 40 minutes, so I'm not exactly sure why we had to get the judge to come in for the all rise just to get the attorneys back for a sidebar. But we'll stay with this. You're looking at Kevin Stannard. He is 61 years old, has pleaded guilty to attempted felony assault, strangulation, and possession of a firearm in a liquor permitted premise. That's basically having a gun in a bar. This goes back to May 5th of 2023 in Cleveland, when Stannard apparently attacked a woman, even though he's a Cleveland police officer, was at the time. We can tell you that when Stannard was charged last August, the city put him on, relieved him from duty and suspended him without pay pending the outcome of the case. It was then November 1st, about a month or two later, that Stannard went ahead and retired on his own on November 1st. And then we get all the way to January, late January, when he decided to go ahead and plead guilty to a number of charges. Again, attempted felony assault, strangulation, and possessing a gun in a bar. And at his arraignment back on September 7th of 2023, the victim got up in court and told the judge that this was not the first time she had been assaulted by Stannard. We're not sure what the relationship is. We may find that out today. Remember, in the state of Ohio, it is required that at a sentencing, any victim is allowed to get up and give their victim impact statement to the judge. Basically tell the judge how this has impacted their life. And oftentimes we hear from the victim tell the judge what they are hoping for when it comes to a sentence, whether it's the maximum or what other terms. But again, you can see the judge is meeting, having a quick sidebar with both the state and Stannard's attorney. This has already been delayed. This was supposed to go off at about 9 this morning. Then we were told it would go off at 10:30. It was right around 10:30 that all the attorneys were called back into the judge's chamber. They were there for about 40 minutes. And now 30 seconds into the all rise, the judge needs yet another sidebar off the record here. So not exactly sure what the issue is at hand. We have been told that at least there will be at least one victim that will give an impact statement, and that they do not want their face to be shown. So we will do our best, and our photographer in the courtroom will make sure that that doesn't happen. We get that request quite a bit, but it's strange to say the least, this delay, continued delay, in what would appear, although the circumstances are not routine, the fact that you have a former Cleveland police officer about to be sentenced, these charges that he's pleaded guilty are not all that uncommon. Now, perhaps part of the plea bargain, was there a directive that he can never be a police officer in the state of Ohio again? There could be a number of things that they are debating out here, but it looks like we will get underway. Let's get to the sentencing now of Kevin Stannard, the former Cleveland police officer.
Let's go on the record in case number 684049, case Captain State of Ohio versus Kevin Stannard. Mr. Stannard is present in court today along with his counsel, Mr. Dan Mashevitz, and the state of Ohio is represented by Mr. Brandon Pateo and Andy Rogalski. As I came out just now, I saw a lawyer in the back of the courtroom. Maybe he was standing on this side of the divider, a gentleman by the name of John Stannard. Mr. Stannard, how are you this morning?
I'm well, thank you, Your Honor.
For the record, it has come to my attention just now at sidebar that Mr. Stannard, who I've known for north of 25 years, practicing law in the same building, having clients in common, that he is related to the defendant. I can tell all of the parties that that will have zero effect on my sentencing here today. In fact, I've had extensive conversations already off the record in chambers with the parties just generally discussing the matter, all not knowing of this relationship. But because that relationship does exist, it's always the court's inclination to do the same thing in the bright light of day that I do under the cover of darkness. So if I'm aware of this relationship, I want to put on the record that the relationship exists so that there's no secrets here. I'll emphasize, I have absolutely no concern that that's going to cause any conflict in my sentence today, but I want to give the parties an opportunity to be heard if they have concern. I'll turn to you first, Mr. Patel.
No objection as to that, Your Honor.
Mr. Mishevitz?
Your Honor, thank you. We have no concern or objection. Thank you.
Okay. Mr. Stanner, you're certainly welcome to stay.
Thank you very much.
So as I indicated, this is State of Ohio versus Kevin Stannard. We're here today for purposes of sentencing. There was a sentencing memorandum filed on Mr. Stannard's behalf by Mr. Mishevitz. I've got numerous letters in support of the victim here, not just her own impact statement, but other letters in support. And I've got a pre-sentence investigation. Have you all had an opportunity to review this pre-sentence investigation, Mr. Patel?
Yes, Your Honor, and I found no errors or corrections to be made.
And Mr. Mishevitz?
Yes, Your Honor. Thank you.
All right. So with that being said, I'll turn to you first, Mr. Patel, for comment.
Thank you, Your Honor. As the court knows, we're here today for sentencing on 3 felonies, 1 for attempted felonious assault of Teresa Kennedy, 1 for strangulation of Teresa Kennedy, and 1 for illegal possession of firearm in a liquor permit premises. Each of these offenses occurred on May 5th, 2023 in Cleveland, Ohio. The first 2 offenses were committed by Mr. Stannard against Teresa Kennedy, who was a longtime friend and almost as longtime girlfriend of Mr. Stannard. That day, May 5th, 2023, Mr. Stannard had been working initially in his capacity as a Cleveland police officer. During part of his shift, near the end, he was drinking while on the job at the VFW bar in Euclid, Ohio. Shortly after, he was confronted by Teresa Kennedy with her concerns about his drinking. He was, at approximately that time in the afternoon, working secondary employment, not as a police officer, but as an armed security guard. Ms. Kennedy expressed concerns to Mr. Stannard, was able to convince him to leave his secondary employment for a period of time, and then upon returning Mr. Stannard to his vehicle, there was a confrontation during which Mr. Stannard began assaulting Ms. Kennedy, taking possessions from her, including her police-issued radio and her phone, her cellular phone. The phone was never recovered. During this assault, Mr. Stannard struck Ms. Kennedy multiple times. He also strangled her. After this assault, Mr. Stannard left the area, was separated from Ms. Kennedy. Later, in the early morning of May 6th, he was involved in a single car accident. The issues related to that are not part of this indictment. Ms. Kennedy, the next day, appeared for the first time for treatment related to the injury she sustained on May 5th.
Was there a DUI charge that stemmed from that single car accident?
No, Your Honor. My understanding of that case, and that occurred in Euclid, Ohio, was that Mr. Stannard's injuries were such that he was in very critical care for a significant period afterward, and charges did not stem from that incident. Ms. Kennedy did begin treatment the next day. She went first to an urgent care provider and then went for much more comprehensive emergency room treatment. She believed at the time that she had broken ribs, that her hearing had been affected, During that medical visit, she learned about an additional medical issue. Treatment for her various issues has continued up until yesterday when she had an appointment related to her continued hearing loss. In addition to the other treatment, she had severe pain in her ribs that lasted at least a month. She also exhibited blood in her urine for a sustained period after the assault. Of note to the state in this case is that this was a long-term relationship. In speaking to Ms. Kennedy over the past several months of this prosecution, it was made clear that this was not the first assault committed by Mr. Stannard against Ms. Kennedy. This was merely the first time that she was able to come forward and file a police report. This investigation was handled by Internal Affairs, and Ms. Kennedy has been a consistent and willing participant in this prosecution. She is here today to make an impact statement to the court. I know the court has taken into account what she provided through my office as well as through the probation department. And if the court would permit, her son, Sean Manzak, would also like to make a statement this morning.
I'd be happy to hear from both of them.
Thank you.
How are you, Ms. Kennedy?
Hi, Your Honor. I'm okay this morning. How are you? Okay.
What do you have to say?
Okay. Thank you. It's 2 pages, if that's okay.
No rush.
Okay. And this is my son, Sean. Okay.
Tell us your full name and spell your last name, just for the record.
Okay. My name is Teresa Kennedy, and it's spelled Treasa, and my last name is spelled Kennedy. Okay. You ready? Okay. Okay. All right. I wrote this letter for you, Your Honor, so I could try to put in words what happened on May 5th. On May 5th of 2023, I was brutally beaten by Kevin for simply trying to stop him from working in uniform while highly intoxicated. I told Kevin that I was going to call Lieutenant Montanaro from the 5th District and have him come down to the area of 21st and Payne to help me remove Kevin from being at work in uniform while highly intox. Kevin told me, "You're not a lieutenant anymore, and no one gives a fuck about you. They don't like you. You are a snitch." And Kevin prevented me from calling the 5th District by violently beating me and taking my phone and my departmental issued firearm and my portable radio away from me. I tried to run away from Kevin, but he hunted me down like an animal hunts its prey. He punched me in the left jaw, ear, and head area. I'm sorry. And then he grabbed a handful of my hair and pulled me back towards him by stating, "Come here, you little cunt. I'm going to kill you." He then began to strangle me. The last time I looked into Kevin's eyes, he was strangling me, and I could not breathe. I felt so much disbelief. I was in shock, and I immediately felt devastated. I really thought this time he was finally going to kill me. All I could think about was how sad my son would be if I die and they discover my body. It was a struggle to stay awake and alert through the remainder of the attack. The punches I was taking to my right ribs and kidney area helped me stay awake because it was so painful. All I could focus on was the pain. Well, I tried to cover my head with my arms and focus on trying to be able to breathe again. I was laying in the car and he grabbed me by my left knee because I've had surgery on that knee before, and he dragged me a little bit towards him and said, "Give me that fake injured knee, you little bitch," and he started punching it and twisting it. And then luckily he finally stopped. So I laid in the car for a little bit and tried to get my bearings again. And he came around to the right side. And he was fussing with my gun, but I had a new tricky holster, so he couldn't get it out. Because he had pointed my gun at me in the past, but he didn't get it out of the holster that time. But he took it with him. And he went to his car. I was attempting to prevent Kevin from placing himself as well as the public in jeopardy because he had been drinking since noon at the bar and he doesn't get off work till 2. And he did crash his car into a pole in Euclid that night. And the Euclid policeman who was on scene called me and said the firemen were mad because he was drunk and that they covered for him for his OVI because they felt bad. They said they called me to come pick up his gun because they knew I was his girlfriend, but I couldn't answer because I didn't have my phone because he stole it and I was in the hospital. So when I went to urgent care, they said I was too injured and they sent me to Akron Hospital instead. Sorry. Okay, I'll go into some of my physical ailments. During the CT scan at Akron Hospital, they did a scan on my head because I told them I got punched there and I couldn't hear too well. And they discovered a brain aneurysm on my left side, behind my left eye, that was 10 by 3 millimeters. My hospital discharge paper said that one of the causes of brain aneurysm is head trauma. And also, Your Honor, I would like to inform you that no one on my maternal and no one on my paternal side of the family has ever been diagnosed with a brain aneurysm. My neurosurgeon, Dr. Bain, informed me that I will need brain surgery if my aneurysm gets to 5 millimeters because it sits directly behind my left eye. And Dr. Bain said I could lose the vision in my eye if it gets to 5 millimeters. In January, Dr. Bain told me it's 4 by 3, so I'm 1 millimeter away from needing the surgery. From time to time, I do experience kaleidoscope vision in my left eye now, and I never had that before in my life on May 5th. I'm sorry, I only have one more page. Okay. I received a CT scan of my kidneys because I continued to pee blood for 3 weeks, so they sent me to a urologist. And in the CT scan, they discovered that my rib was broken. There was a fracture in my rib that covered down by my kidney. Dr. Turk is my urologist who discovered that, and he told me that my ribs did its jobs by sacrificing themselves to protect my kidneys. Dr. Turk said my kidney was damaged, but that it will heal and we will monitor it. I still have a lump on my back to this day. It hasn't fully healed. Oh, and by the way, I never had a UTI, so none of the blood or anything was in my urine from that, and I included all my prescriptions and tests for Prosecutor Pateo to see, so it wasn't from that. He said it was from the kidneys. My left jaw was super tight and my neck was stiff. However, luckily those both healed. However, my left ear is still ringing, and sometimes my hearing shifts to underwater sensation. My ENT yesterday at the doctor's appointment said I tested again for hearing loss in my left ear because that was my second test since the incident. And so he approved me to get another MRI on my head, but this time on my ear as well as my brain. And that is scheduled for April 17th of 2024 because I have to get my brain aneurysm checked every 6 months now. So we'll make a plan for my hearing loss after we do the MRI in April. I'll mention a little bit of the past abuse. I can remember 15 times, and Kevin would write me a lot of apology letters.
15 times for physical abuse?
Yes, sir. 15 times. I spent $17,000 extracting all of my phones, and I have text messages and evidence of us going back and forth and letters he writes me after he beats me, as he came over once with the fertility test kit because he knew I wanted to expand my family to have a baby. So he would say, I'm sorry, and send me letters, and I have all those letters. And I showed some to Internal Affairs, and he brought over a fertility test kit, and I got an ovulation predictor kit, and he would promise to come back and give me a baby and do it right this time and get counseling for his drinking and his physical abuse. And we went to separate counselors, and then he was mad because he wanted to see my counselor, but my counselor wouldn't see him because she said he needs to see his own, so he said he was going to his own in Menor. Well, I don't know what happened with that because the abuse was really bad, Your Honor. They took my gun from me for it. This was the 4th time, and it was not the first time he ever hit me in the head. And in January 22nd of 2021, he drove me towards Menor because he blocked me from getting in my Uber. He said that he was going to pay another policeman to set my worthless carcass on fire. To set my worthless carcass on fire. And he came back, and then he beat me and made me stay on the ground. And he left, and I told Bert, I showed you all the paperwork from IA. I gave him all he wrote me a check and paid my hospital bills because I missed a whole bunch of work because I had a concussion. Because he was punching me so many times in my head. No. And he just begs me and says it's his stressful life and his whiskey and everything. And then there were so many times I would take all day to tell you, but I have text messages of us talking about and going back and forth and him offering to pay my bills. And then the last thing I was going to say was Kevin was my best friend in the entire world. I treated him like a king. I always made sure I cooked good, healthy meals. I was kind and nurturing and compassionate. And he always encouraged me not to give up on our relationship. He told me we have been through too much to throw everything away now. He told me that he was passionate about me and that he only hit me because he cared. And he said if I didn't care, then I wouldn't give a fuck who you talked to or what you were doing. He said, I hit you because I'm passionate about you, which I know now is wrong. I know that's not true. He promised to be a better man, and he blamed his domestic violence on his drinking whiskey. And he always promised this was the last time, but unfortunately for me, it was never. And he even promised to spend an eternity in the afterlife with me, and he even said once, even if we both come back as frogs, as long as we have the same lily pad, he would be happy. And I loved him, and my son loved him, and my family loved him. He went to all the events, my niece, my son, Kalahari, Cedar Point, birthday parties. My mom loved him. My dad, he drank at my dad's bar. He went to my mom, slept at my mom's house. My sister, everybody loved him. My best friend Cindy, everybody loved him. Especially my son. My son really looked up to him because I will say one nice thing about Kevin. He was very, very good to my son. He said it was the first time it ever made him feel like a dad. He was good to my son. He was. And,
So listen, you've taken a lot of energy and given a lot of thought to the things that you want to say to me about how he's impacted on your life, and I appreciate that. Mm-hmm. But I also want you to tell me how you want to impact on my sentence. So you think about a victim impact statement, it serves two purposes. Let me know how the defendant impacted on your life, but also let me know how you want to impact on my sentence.
Your viewpoint or defer it?
yeah, I mean, maybe a little bit of jail, maybe. Because what if he does it to the next woman? It can't be just me. It can't. Maybe it's not. He says it's only me, but I don't know. I mean, it's not like it was the first time. The first time he ever beat me and took my gun was in 2012. And I showed the sergeant everything. I went to the scene, took pictures. So it's been 13 years, and I just wanted to love him and thought if I finally was able to give him a baby, he would be happier or something. But this is my only son. This is all I got.
I appreciate you coming down. I appreciate the courage that you showed.
Okay, thank you, Your Honor.
Did you want to speak as well?
Yes, Your Honor. Sean Manzak, Mandzak. My message is the following. In Jesus' name, repent, because your soul may be in danger.
I certainly appreciate your faith and your expression of your faith. But I'll ask you the same question that I asked your mother. You know, two ways to think of this impact statement, right? How has he impacted on your life through your mother? And then what is it that you want to see me do in terms of how you might impact on my sentence of the defendant?
I don't know. I pretty much defer that to you.
Because he loves him too. It's hard for us to say, Jill, but I know that's what might be a little bit, might be what he needs, but it's because me and Sean loved him. That's why it's hard for us.
Although there's no specific count of domestic violence here, certainly there are there's a sense of domestic violence in the air, if you know what I mean. In these situations inside of a family, there's often an awful lot of pain and emotional sort of pulling. So I appreciate the struggle that you're sort of dealing with, and I respect your statements.
Thank you, Your Honor.
Thank you.
Thank you.
Mr. Pateo.
Thank you, Your Honor. Briefly, in addition to any other sentence, there was agreed restitution in the amount of $2,580.52. That was for the cellular phone. $2,580.52. That was for the cellular phone that was never recovered, that was taken on May 5th, and for the medical records or medical expenses for the out-of-pocket non-insurance covered costs. Additionally, I did want to note that in addition to her son, several members of the victim's family have taken time to be here in support for her. In addition to Sergeant Egelmeyer, who is now retired but was the investigating officer from Internal Affairs. Finally, I just wanted to note that while the defendant's sentencing memorandum touches on the supporters that are here for him today in court, I think in a significant portion of the statement the court just heard from the victim, you can understand that one of his biggest supporters for decades of his life was Teresa Kennedy. And the way that he repaid Teresa Kennedy for her trying to intervene and help him on May 5th was to assault her. I'd ask you to take that into account. Thank you.
Let me ask you, Mr. Ted, before you have a seat, a couple questions. First of all, Ms. Kennedy makes references to a great number of physical ailments. What of those ailments do you directly attribute to the defendant?
Based on the medical records, Your Honor, the pain in her ribs that led to multiple treatments and scans of her abdomen, core area. Immediately after the assault, she indicated that she had hearing problems that, as the court heard, had been sustained up until and through a meeting with the doctor yesterday. Additionally, the blood in the urine that she identified as being caused directly and not having any issues with prior to May 5th. Additionally, the first time that she learned of the aneurysm came afterwards. I have spoken to her about that, and there was no causal identification that was from the past abuse or the May 5th abuse, although that can't be ruled out.
Understood. But there has not been established a direct link between the assault on that day and the aneurysm.
Not in any medical records I received, but because she went for treatment on May 6th, and during that treatment and during the scan of her head for the hearing problems that were caused, that was identified at that time, and so the treatment has been throughout.
But if the matter had been tried, the government would have certainly alleged that the hearing loss, the blood in the urine, and all of the rib pain and injuries would have been attributable to the defendant.
Yes, Your Honor.
Last question. it's not uncommon in these sort of domestic situations that we have victims who come in and don't ask for the courthouse to be dropped on the defendant because of that love, because of that sort of tearing between a love for the defendant, but yet a desire also for justice. What position has the government taken with respect to sentencing?
The position of the government is to support the victim's wishes, Your Honor. I believe the victim would like to see the defendant serve at least a period of time in jail. The government believes that's appropriate based on the evidence in this case, the convictions, and all the other information available to the court.
So in this case, even in the face of all of these injuries and these allegations of long-term abuse at the hands of the defendant, the government is not asking for prison.
Not specifically, Your Honor, but of course, it is within your purview.
I'm aware. Thank you, Mr. Patel.
Thank you.
Counsel for the defense.
Thank you, Your Honor. Your Honor, thank you. Respectfully, before we address our specific comments, just to follow up on Ms. Kennedy's comments to the court, this honorable court's questions, very direct questions to the state of Ohio, the state of Ohio's response. As a result of the discovery in this case and our working towards a resolution in this matter, we were able to obtain and receive medical records and to directly address those questions and those issues that have been brought up. What was indicated in the investigative reports and the medical records from the next day were that there was no acute reason for the admission, that there were not broken ribs, and that there was microscopic hematuria, which would be what is being referenced as blood in the urine. That is something that is very common. I say that also the investigation itself indicated that there was no bruising. She was very thoroughly looked at by the investigator according to the reports, neck and back and otherwise. That is as it relates to the injury specifically in the court's questions and concerns and that matter. But I want it to be said that Mr. Stanner today takes full responsibility. Your Honor, he's pled to a felony of the 3rd degree, as well as a felony of the 4th degree, and a felony of the 5th degree. Your Honor, he has no prior criminal history, nothing on his record whatsoever. No misdemeanors, no felonies, nothing. He served 27 years as a police officer after graduating from St. Joe's. He went to EMS school, became an EMT. He went to the academy. He's had letters from the chief, accommodations because of the things that he's done in the field in terms of bravery. In 27 years, he's had no blemishes on his record. As a result of this matter and him being willing to take responsibility here and give himself closure and Ms. Kennedy closure and his family closure, he's had to step away from that. He's no longer a police officer. He knows that he'll never be able to be a police officer again as a result of this. And we'd ask the court to consider not only is he taking responsibility, but that punishment and that finality that he can never work in that field again. Your Honor, while this case has been pending, Mr. Stanner's been on 2 monitors. One was a GPS monitor, and one was a TAD monitor, which is basically an alcohol monitor that's on his skin at all times to be sure that he's not consuming any alcohol, and the GPS was to be sure that he's not doing anything that could be problematic towards Ms. Kennedy or anyone else, really. And during the 6 months, all of his alcohol tests have been negative, his drug tests have been negative. He's fully engaged, Your Honor, in recovery. He's been attending meetings, and I know, court's seen the log of meetings that was attached to the sentencing memorandum. He's embraced being sober. He's been very open with his family about this situation. His wife is here today. His mother-in-law is here today. His brothers are here today. His cousin, John Stannard, is here today. They've been very close for many years. His friends are here today, and they stand behind him. They know that he's not a perfect man. They know the circumstances around the situation, and they still stand behind him. I know the court, this honorable court, has seen the letter from James New, which is his supervisor at Medical Mutual, where he worked for over 10 years. 20 years. Yeah, that's correct. And also from Lieutenant Mike Butler, who was a supervisor at the Cleveland Police Department. Never did they see any problems with him, Your Honor. On the night of this incident, Your Honor, Mr. Stannard admits that he could have handled it better, that he should have handled it better, that he should have stepped away from this situation many, many, many years ago. When this affair started, Miss Kennedy was his supervising officer, and the night of this incident, he was trying to get into a secured area where he could be alone, gated area. She was able to gain access to that area. After this incident, they did go to the VFW together, and I think what's important is that it sounds like both of these individuals, he's the one that's before the court, and we understand that. But it is important that both of them, it seems, have understood that this relationship is not going to be reconciled through counseling or any other steps, that they have to go their separate ways. He's taking responsibility for his side of the street, and that's what he wants to do here today. He's taking responsibility for his issue with alcohol. He's addressing it. He's not just talking about what he's going to do, what he might do, what he'd like to do. He's doing it, and at his age, it's been a change, but he's embraced it and he's done it successfully. And we'd ask the court, the probation department, in its report, Your Honor, indicates that they place Mr. Stannard at a low risk, considering all the factors, his lack of record, his having pled guilty to a felony of the third degree being the highest count, and all the other facts and circumstances related to him. They place him at a low risk, Your Honor. We would ask the court respectfully to allow him the privilege of a community control sanction, Your Honor, and we ask the court to do it with certain parameters. If the court sees fit to continue him on these monitors, to be certain that there is no contact, to be certain that there is no alcohol, and quite frankly, it's a punishment. It's humiliating for a grown man that's led a law-abiding life and has a family and is trying to take responsibility to have to wear monitors around their leg. It's not an easy situation. We'd ask the court to consider allowing the privilege of a community control sanction, even if it involves some level of house arrest or otherwise, Your Honor. And I know that he wants to address this court, and I know that he wants to address Mrs. Kennedy directly, Your Honor. Thank you.
One thing that's not going to happen is he's not going to address Ms. Kennedy directly. He's going to address the court. He can share with the court whatever sense of apology he has or sense of remorse he has for his behavior. He can address the court, and Ms. Kennedy can hear it.
Yes, Judge.
Is there someone else from the family you wanted to have speak, or is it just your client?
Your Honor, everyone is here on support. For his support, I don't know that we're going to have anyone speak.
I'd like to say something. Am I allowed to say something?
May I have a moment, Your Honor?
You bet. Mr. Standard, you have the right of allocution. Just means that you have the right to be heard at the time of your sentencing. If you'd like to speak, you don't have to, but if you'd like to speak, I'd be happy to hear what you have to say.
Okay. Well, I'd like to apologize to Teresa Kennedy. I am very sorry for, I did not mean to do anything to ever hurt her in any way, shape, or form. And I am taking responsibility for my actions and the mistakes I've made. And I would like to apologize to the court as well. I'm trying to move on with my life with my family. I've abstained from any alcohol in over 9 months now, and I'm going to continue to do that for the rest of my life. And live a good family life. I'm fully retired now, and that's how I'm going to live my life.
You say you want to apologize to the victim, Ms. Kennedy. What are you apologizing for?
Well, I'm apologizing actually for crossing the line, never being involved in a relationship outside of my marriage, and not.
That's an apology you probably owe your wife. I'm
Well,
asking you, what is it that you want to apologize to Ms. Kennedy for doing?
Well, forever really being involved in any way, shape, or form.
Okay, so you don't want to apologize for strangling her, because that's what you pled guilty to.
I do want to apologize for those things, yes.
Well, I'm asking you, because I'm about to sentence you.
Okay.
I want to get a sense from you of whether or not you are a person who has learned from their mistakes and wants to move on as a better person,
Yes.
as a person who, in an instance where you pled to a violent crime, wants to move on and be nonviolent. But what I've heard so far is that you want to apologize for infidelity, that's to your wife,
Right.
and then to Ms. Kennedy for being in the relationship. Is that the sum total of your apology?
No, that's not the sum total, Your Honor. I want to apologize for any physical.
Mr. Stanton, let's take a break. Just a
Okay.
moment. Let's take a break. What I want you to appreciate is that I made a commitment to your lawyer, that I would hear you out,
Okay.
right? That I wouldn't draw any conclusions until I've had a chance to hear from you. So the reason why I take the time to say that is because I want you to appreciate that your words are important. So I want you to take your time and gather your thoughts. Because if you don't even have the good sense to apologize to a woman for strangling her after having pled guilty to strangulation, that could have a real negative effect on your sentence. Now, this isn't a trial. This isn't a whodunit. You've pled guilty to these things. So I'm going to ask you one more time, and I'm going to give you a chance to get your thoughts together. What is it that you'd like to apologize to Ms. Kennedy for?
I'd like to apologize to her for strangling her and ever putting my hands on her in the past. And yes, I do want to follow in the path of having a good, clean, normal life with no physical abuse or anything like that whatsoever towards anybody ever in my life. I'm very sincere, and I don't know what else to say. I'm very sincere. I'm very, very apologetic for ever having put my hands on her ever. I've never.
Before imposing sentence, the court notes for the record that it has considered the record here today, the oral statements made here today, the pre-sentence investigation, which have been significant. This file was reduced significantly by the government. I don't get involved in plea negotiations, but the difference between what you were charged with and what you've actually pled to is dramatic. Mr. Mishevitz did a fantastic job in convincing the prosecutors, for whatever reason, to reduce this from a first-degree felony where the minimum sentence would be 3 and the maximum would be 11. So I've considered the plea negotiations, the victim impact statement, which is my obligation to do. It's a meaningful statement. It's a remarkable statement. It's a statement that evidences a cycle of abuse that's almost cliche, right? We hear it so often where you have an abuser that assaults a victim. The victim, over time, begins to forgive him, focuses on the positive qualities, begins to minimize the negatives. That manipulator, that abuser, convinces her to open up her door again to him, and then the cycle goes on. Another instance of domestic violence, followed by another instance of abuse. So the victim impact statement is very meaningful to this court. And I'm moved not just by her statements as she recounts the details of your relationship. But I'm moved by the fact that she's not in here, neither is her son, asking me to send you to prison for some long period of time. I think at most the victim was able to bring herself to put her fingers together and say he needs to at least lose his freedom for this long. And that's a testament to her character. Her son could have asked that the book be thrown at you. Instead, he spoke of his faith. That's the pain that you've put these people through. They're so torn that they don't know really what to ask the court to do, how to deal with this scenario, because it is so difficult. These intra-family situations they're awful. They're awful. They just tear at families. I've also considered the sentencing memorandum. I've already remarked that your lawyer did a fantastic job in getting this charge reduced against you. But there are valid points that are made, and there are people who have expressed a real affection and regard for you. So there's no doubt in the court's mind that you have positive qualities. It's not lost on this court that you have served the community as a police officer for 27 years, and I don't think you ought to be punished for that when there's a misstep on your part. Generally, when police officers misstep, I don't think they should be treated more harshly than a butcher, a baker, or a candlestick maker. But the difference here is your misdeed is a significant one. The court must and has formulated its decision based upon the overriding principles and purposes of felony sentencing, namely to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on the state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. The court must and has also considered the seriousness and recidivism factors relevant to the offense and offender, pursuant to ORC 292912. The court must and has ensured that the sentence being imposed does not demean the seriousness of the crime and the impact it has on the victims, and is consistent with other similar offenses committed by like offenders. Finally, the sentence is not based upon any impermissible purposes, namely the race, ethnic background, gender, or religion of Mr. Standard. Do you understand all of that, Mr. Standard?
Yes.
This is an interesting case to me in that you have, on the one hand, these 27 years of good work in the community. I have no reason to believe that you've behaved in any way less than honorably as a police officer in the years that led up to this event, right? So I credit you for all of that. You're not charged with some of the other things that Ms. Kennedy made reference to in the past, an event that happened in 2012. That's not a factor in the court sentence because it's distant and it's not what we have to adjudicate today. So I credit you for all of that good work that I have no reason to believe you didn't do in the community working in law enforcement. I think when cases like this happen, that involve law enforcement officers, what it really does is just put another blemish on law enforcement generally. You can imagine if we rewound time a bit and you were a proud police officer and you learned that a fellow officer had assaulted, beaten, and strangled a woman while drinking just after having finished his shift. Meaning you were drinking on shift, just after you finished your shift, you assault this woman and strangle her. Imagine if you were an officer, how you would feel about the tarnish that would have on the badge. So we've got the years of good work, the years of good police work serving the community. And that's not lost on this court. But in the end, your behavior was reprehensible on that day. And I just can't imagine a universe in which a judge ought to be putting people on probation and just releasing them back into the community after they've pled guilty to a violent attack on a loved one that not only includes punches, but also strangling someone who you purport to have been in a relationship with for over 13 years. So in the end, although as I've indicated, I've got a lot of respect for your lawyer and the work he's done, and I understand that the prosecutors have reduced this charge significantly, it's the court's position that this is the type of case that incarceration is for. You see, we send nonviolent offenders to prison every day. In this county, we set records for sending nonviolent offenders to prison. This is a violent crime. This is what prison ought to be reserved for. You know, your lawyer mentioned closure, and I understand the comment, but there's no closure without justice. And justice requires that you be incarcerated today. In count one, it will be the sentence of this court that the defendant will serve 2 years at the Lorraine Correctional Institute. In count four, the defendant will serve 1 year at the Lorraine Correctional Institute. And in count five, the defendant will serve 6 months at the Lorraine Correctional Institute. All of those counts will run concurrent with each other for a total sentence of 2 years. Now, let me say this. I believe you might be a candidate for judicial release. And I'll say that right up front because I don't want anybody to be surprised if I consider such a motion when I believe it's timely filed. You know, your service to the community really is meaningful to me. And so I've got to try to find a way to sentence you that protects the community, keeps the community safe, but yet punishes you in a real earnest way. And I just don't think I can do that without incarcerating. You know, your sobriety ought to be at the forefront of your mind every day. I'm very happy to hear that you're testing negative. And to the extent that you go and begin this prison sentence and you want to come back out early, I may very well be willing to support that. But it will be with the understanding that there's going to have to be continued sobriety throughout any sort of a subsequent period of probation. It's this mixing of alcohol and guns and violence that the court can't get past. It's just too much. So understand that if you serve your complete prison sentence, you will be subject to a period of post-release control. Post-release control in this case would be for a mandatory period of 1 year up to a maximum of 3 years. And that's because this is a third-degree felony, but it's a third-degree felony crime of violence. So there's a mandatory minimum 1 year post-release control. The restitution will be ordered in the sum of $2,580.52. Is there anything else that needs to be spread on the record, Mr. Pateo?
I have to stay, Your Honor. Thank you.
Mr. Mashevitz?
Respectfully, Your Honor, we ask the court to suspend any court costs as he's going to be going to the institution.
By all accounts, he's got the resources to pay the court costs. I'm not going to fine him, but he's going to be responsible for the court costs. Anything else, Mr. Mashevitz?
No, Your Honor.
All right, we're adjourned.
Dan DeRose with 19 News. The judge sending a message here to Kevin Stannard. You're about to see the cuffs put on a former police officer. The judge was not mincing words here and commended his attorney from taking what was a huge list of charges and getting them reduced significantly. And you really got no pushback from the state. The judge asked the state several times, are you asking for prison time? Are you asking for jail time? And they said, we're siding with the victim in this case. And the judge even acknowledged this is sort of the pattern you see with domestic violence cases, although he was not charged with domestic violence, that you have the victim who put her fingers up and said that I hope he gets a little jail time. The judge was not satisfied with that. You see Mr. Stannard there trying to say goodbye to his family. His wife, when you start to unpack this whole thing, this was his girlfriend of 13 years, and his wife is in the courtroom, and he allegedly, and now has been convicted of beating her severely. And you heard the victim stand up in court and say this was probably the 15th time that he had beaten her. It was just the only time that he got caught and that charges got pressed. Just a lot to unpack here, a veritable soap opera in taking place in court here, but this is real life. And you heard the amount of injuries for the victim in this case. Again, she was the girlfriend. Just listening in here to see if family taking his personal possessions. You see his brother, who is also an attorney. We find out that's what the delay was in this, is that the judge has worked with his brother as an attorney, but wanted to make sure that that would be not seen as a bias in his sentencing, and I would say not. He's given 2 years, and we see this disability by Mr. Stannard as he's walking out here. You heard that the night that this fight occurred, he continued to get drunk and then went out and smashed his car into a pole in Euclid. And you heard the firefighters, according to the victim, they were mad because the police there stood up for him, covered it up, let her come get the gun, but she couldn't do that because, well, she was in the hospital at the time. So you've got that whole aspect, that whole side of things that looks really disgraceful. Stannard was drunk while on duty that day. She tried to get him out of the bar because he was on duty at the time. He then leaves the bar. He's no longer on duty, but he goes to his side job that officers often have. He's still drunk, and that's when the attack happened. And from all accounts from the victim, this was a vicious attack, at one point even grabbing her knee that had surgery on it, using some expletives, saying that this was a fake injury, and proceeding to yank her around by her knee and twist and turn it. Just a severe confrontation, physical abuse there. And instead of what he was looking for is to be able to go home and sit on house arrest for a short time, no, he's going to prison. The judge saying that this could be eligible for judicial review, that he would be willing to look at this somewhere before that entire 2 years and let him out. But that he felt this is a case that is demanding of some prison time. Just a very interesting sentence that just played out here in Cuyahoga County. We will have a complete wrap up on the sentencing of the former Cleveland police officer when our news starts at 3 o'clock, when we start 3:30. Actually, we have soccer today, so our news will begin at 5 o'clock. If we have anything else that breaks, it'll be right here on our digital platforms. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media @Cleveland.